Good morning, everybody. Welcome. This is the Vishnick McGovern Milizio webinar, Neighbor Issues Surrounding COVID-19 in Isaias. Everything you need to know from the insurance and legal perspectives. I'm Roy Schwartz, Director of Marketing and Business Development. A little bit about our firm. Vishnick McGovern Milizio is a full-service firm. We have almost 20 areas of practice, offering comprehensive legal service tailored to all business and personal needs, with offices in New York City, Long Island, and New Jersey. We invite you to visit us and learn more at vmmlegal.com. And if you have any questions, please feel free to email us. I'd like to introduce our first panelist, Richard Apat. He is the head of Vishnick McGovern Milizio's personal injury practice, as well as real estate litigation practice. He has over 30 years of experience as an attorney in real estate and personal injury matters of all kinds. Our second panelist is Roger Eltringham, a senior sales executive at AssuredPartners Northeast. Roger has over 40 years of experience involving all types of property and liability claims, as well as coverage analysis for both personal and commercial clients. Richard, take it away.
Thank you, Roy. Hello, everybody. So how did we get here? We had the storm come in, Isaias, and there were a lot of trees that were downed all over Long Island. And as an attorney that does personal injury as well as real estate, I've dealt with this issue many times in the past. And it is surprising to many people to find out who may or may not be liable when a tree goes down. So Roy, our head of marketing, decided he could put something together. We ended up getting on TV, and here we are. He said something about everything you need to know. He is overselling, but that's his business. But let's just talk about this tree issue for a bit, which Roger has also dealt quite a bit with. So many people think that if a tree is on property A and it falls onto property B, that property A is going to be responsible. That's not necessarily the case. As a practical matter, it's almost never the case. And the reason I'll go into in a minute. But trees, as a general rule, whether it's a storm or whether it's not a storm, have to be maintained by the owner of the tree. However, a tree, a portion of the tree can go onto somebody's property. The branches can go onto somebody else's property. The roots can grow into somebody else's property. And if you are the neighbor, if you're B, you can trim that tree up and down the property line. So you can trim all the way, you have the air rights that go up, so you can trim all the way up, and you can actually cut roots. Cutting roots is not a great idea because it's going to undermine the tree and have a better chance of it falling. But in the analysis where a tree just falls, and typically we have this come up in the storms, people will not be responsible. The owners of the trees will not be responsible because they didn't have notice that that tree was in danger of falling. We'll talk about an act of God in a minute, but as a general rule, most people are not sophisticated enough to inspect trees in a manner, and they're not obligated to, where they could determine if a tree is at risk of falling. If there are outward indicia of decay, the tree is barren of leaves, you can see that it's discolored. Now you're on notice. Now there's a possibility there's something wrong with that tree, and now you do have an affirmative obligation to have a horticulturist or some other person look at that tree to see if that tree is in danger of coming down or branches are in danger of coming down. But trees oftentimes can be hollowed out inside or begin to hollow out inside, and nobody will know that from the outside. You'll see new sprouts, new leaves, everything, and that tree is still at risk of falling, or a branch is at risk of falling. So that's the reason why the person who owns the tree generally is not going to be responsible. The insurance take on this is similar, but there's a different aspects to it. Roger, if I can bounce it over to you for a few minutes, and can you talk to everybody about the insurance, the way the insurance companies look at these claims?
Thank you, Richard. I had the unenviable task of trying to make insurance sound interesting today, so cut me some slack here. Basically, as we've just seen with this most recent storm, tree branches, tree everything is all over the place. And as far as insurance is concerned, there are different ways it's approached depending on where the tree falls. If it falls on a structure, your garage or your house, insurance carrier is going to pay to remove it and pay for the damage that it caused in striking the house. Sometimes the tree will just fall in your yard and not really do anything except create a big mess. In those cases, the insurance tends to be more limited. There's not a big amount for insurance companies to give you as far as just getting rid of the tree. We saw that even in my own neighborhood, the tree fell across the street actually, and the village took some of it out, but the neighbor is still responsible, or the owner is still responsible to get rid of the stump and other other things. So the homeowners can be disappointed sometimes to learn that the insurance is not going to give you very much at all. Maybe $500 at most $1,000, unless it's a high-end insurance policy, and then sometimes they have a bigger limit for tree removal. So, and to complicate things further, no homeowner insurance policies are not uniform. So you have to really check with your own to see what that particular company gives you and doesn't give you. So how does that sound?
That's pretty good. Can you just address the issue of maybe an owner seeing that their tree doesn't look so healthy, doesn't look so good, and maybe is on danger of falling on their house or a neighbor's house, and they contact the insurance company and they say, listen, I don't want to see something happen here. Would you pay to trim it or anything like that? Can you just address that topic, Roger?
One thing insurance companies are not is proactive. They are reactive. They will react to the claim, and in most cases will pay the claim as it should be. But in terms of preventive maintenance, if you want to consider that, they will not pay for you to have the tree pruned or removed. It's not a part of the insurance contract.
Gotcha. So, and to this point, so you can have personal property, commercial property, property owned by a municipality. The general rule for all properties is that you need to be reasonable in your maintenance and use ordinary care. But, within the city of New York, there have been some cases, and I think a couple within the park, Central Park, where a tree struck and killed some folks. And the analysis occurred where they went back and they looked at the tree branch after the fact. It was, investigated. Obviously, something like that is catastrophic. And when they've been able to show that there was decay, that a reasonable inspection would have shown that, there has been liability. And you can imagine that the obligation, that people are coming into the park, they're utilizing the park. There's some obligation to do proactive inspections. Whereas, in my backyard, I have trees, they're up on an elevated area. If I go back there a few times a year in that area, it's a lot. So nobody in all likelihood is going to hold me responsible for one of those trees. So anyway, that's how this topic started. Now, how do we broaden it out to how is it COVID related? Again, that's Roy in marketing and sales. We're spending a lot more time at home. So issues that occur at home are coming to the forefront. Things that you would normally tolerate, you're maybe not so much tolerating because you're seeing your neighbor who's driving over your property every day, or perhaps the fence is on your side of the land and you didn't want to make a big deal about it before, but now you're thinking about bringing that out. We have gotten a number of calls, received a number of calls in the last 6 months exactly on these points. Today is Friday. Earlier this week, I was in Astoria, brand new client who for years has dealt with the fact that their neighbor, their drain does not work properly and the water is coming onto their land. Again, something that they're home, they're generally not home, so they're at work, they're not seeing it, it's not bothering them. They come home at the end of the day and they see a little water in their garage or something and they don't address it, but now they're seeing it happen and they understand why it's happening. In this particular case, the person's drain is not being maintained. But just to not spend too much time on this issue, but again, it's a neighbor issue, and the issue in this particular case is not maintaining a proper drain. But I will tell you that when everybody builds on their land and they remove vegetation, they have to account for that removal of vegetation. They have to account for the fact that they've cemented over, and now it's a substance that doesn't absorb water, and you need to make sure that you have either dry wells or that you're connected to a sewer and what have you. The general rule is you can improve your land, and if it naturally, because of the natural topography, causes water to flow onto a neighbor's property, you're generally not going to be responsible. But if artificially you redirect the water through a piping system or a draining system or through regrading, that's where you'll end up running into an issue. And there's some sections of the administrative code, there's some sections of the building code of the city of New York that address those exact issues. Another issue that comes up, actually, we had a couple of people that sent in some questions. So let me just address one or two of those now. One of the questions was over here. Hold on a second. Okay, there we go. Okay. I need to remove 2 peach trees in my backyard. I have 2 neighbors who this would affect. What, if anything, do I need to do? If the trees are on your property, you can remove them. The fact that the tops of the trees are on their property should not be an issue. There are times, although with a tree removal, it should not be necessary, where if we had to go into court, there's a section of the Real Properties Actions Proceedings Law. I'm guessing it's 880. I haven't done one of these in a while, but you can get a license to go onto somebody's property to do work, whether you're doing work to your physical structure, your property, or your building, or tree removal. So that's not the issue. Roy, I know you're still there. We can't see you. There was another question, I think, from today. If you can re-forward that one to me.
Oh, yes. This one is, the last one was from Jean. This one was from Alice. I need to remove 2 peach trees in my backyard.
I just addressed that one, Roy. It's the other question.
So you are talking about Alice. So Jean was, client contacts you. I'm assuming she means insurance client. Okay. Client contacts you to write a letter to their neighbor because the neighbor's trees have branches spreading into the client's yard. Client is concerned that the branches will damage their house. What do you recommend?
Sure. So here, and I get this all the time. I literally was getting together with a bunch of friends the other night, people I normally play basketball with, although if you saw us play basketball, you wouldn't consider it basketball. But anyway, we got together for some social distancing drinks, and my neighbor has another issue where his neighbor is videotaping, and the videotaping is going into his backyard, onto his property, and he has young children. And you may be aware, I think it was in 2017 or 18 that Cuomo passed a law about giving people a private right of action if somebody is videotaping into your backyard. But when it comes to the trees, Roy, I'm getting ahead of myself. I'm all over the place. I'm looking at different emails. What was the issue again, Roy?
To pull it up again, but she has 2 trees, right?
Branches. Okay, I got it.
Right. The branches are spreading into the client's yard. The client is concerned that it might affect the house.
Right.
How should he go about it?
Sure. So your home is your refuge. I never try and commence an action at the first drop of a dime or something like that. I want to try and work things out with people. And I've had many clients tell me at the outset, it will never work out with a letter. And I've proved them wrong many times. I've had other cases where I thought I would resolve it, didn't resolve it with letters, but as soon as we put the case into suit, we were able to address the issue. The one that I just mentioned with the water, I drafted a really thoughtful letter of what the problem is, of the damages that it's causing, and all we're simply asking this neighbor to do is to fix this drain. We know it's going to cost money. They're going to have to dig things up. They're going to have to figure out where the break is, etc. But I wrote a really nice letter that any person that picked it up would not say, oh, here's a letter from a lawyer, callous, what have you. No, we're neighbors. We all live in this area. We just want to address a problem. And, can you help us out? I actually have from another lecture I'd done a sample letter. I can get a hold of that. Maybe I can give it to Roy to put on the website of a neighbor letter. But my first letter is always very nice. I write a second letter. If we get no response, I send the letters always certified in regular mail. And if that letter doesn't work, then I will draft a complaint, assuming the client wants to move forward, and I will give one last chance. And at that point I say, you know, if we can't avoid litigation, you know, as of Monday, we'll pursue litigation. And whatever that date is, I file it on the exact date I say I'm going to file it, and we serve it on them. And some of these, you know, become contentious, unfortunately. I have a lot of them that are commercial, but the neighborly ones become contentious, and people are no longer making business decisions. It would be easier to address the issues than to litigate it. Speaking to that issue, Roger, if somebody were to write a letter about the water drainage coming onto their property, I assume you're not going to be doing anything to fix the piping, but you'd have to pay for the damages, or maybe I'm mistaken on that. Can you speak to that issue?
Yeah, in general, with liability insurance, every homeowner policy, or virtually every homeowner policy, has a section for personal liability, and the limits can vary. Some companies will only sell you 100,000, others will sell you 500,000. I suggest, you know, as part of that, buy as many limits as you can. It's not terribly expensive to do that. The policy has, as in most general, even commercial liability policy, has a duty to defend any allegation. So if the homeowner that had the water damage brought a claim against the person with the drain, then that their insurance will defend them. Now, the issue, a lot of people confuse issues of liability with am I covered? And the idea is that with liability, you're covered for defense, and if you're found negligent, the policy will, of course, pay. So, which kind of leads me to another issue, and that is, especially with issues with drains and runoffs of surface water and so forth, a homeowner policy, and most commercial property policies also, will not cover that type of event. You actually need a flood policy, because runoff of surface water, a backup of storm drains, generally the carrier is not going to cover that. You will see in your policy coverage for backup of sewers and drains, but that's inside the house, not from off the street, and not for land, you know, that abuts you. One of your own attorneys in your firm had a terrible case years ago where it rained, it snowed, it melted, and then it froze, and there was a very heavy rain. Water ran off right down the back of his backyard and into his basement, where he proceeded to have several feet of water in his basement. So his homeowner policy did not respond to that. He wasn't happy, but it's not like you can get it some places and some places not. You have to have a separate flood policy, which is not terribly expensive unless you're, you know, by a coastline. But in general, most of those policies are rather inexpensive, and you really don't even need to buy the maximum limits. You can buy, they have 250,000 limits you can get for a house, but you can buy 100,000 limits if you think that's all your damage is going to be. So I would suggest, if you have those kind of situations where the topography does not favor you, then I would consider going. And as long as your community participates in the National Flood Program, you can get that coverage for hundreds of dollars. It's not a lot of money.
Great. All right, so I'm going to move forward, Roger and Roy, with some of the the things that we see a lot of, which are these prescriptive easements and adverse possession. But Roger, just remind me to get back to you, because I'd like you to give a few tips to people as to how they can properly present a claim when the time comes. So we, especially more so within the city limits, but Nassau and Suffolk as well, we will have prescriptive easements. Prescriptive easements are probably the most common of all of these type of land issues that I get in terms of, neighbors, adjacent properties, more than the trees, more than the adverse possession. And what is a prescriptive easement? In simple terms, it's somebody is using your property. They're not taking a piece of the property. They simply use it. They drive in and they drive out. They do this openly, notoriously, and continuously for more than 10 years. And eventually that can ripen into a prescriptive easement. We see this a lot in the commercial context where you have adjoining buildings and adjoining parking lots and adjoining properties with, an ingress and an egress on both. And people will pull into one and exit through the other one. I have two of those actions going right now, one in Nassau County, one in Queens County. So over time, you will have a situation where it ripens into a prescriptive easement, and then somebody else buys the property. It usually always comes about when some new owner comes in and they're realizing that people are driving across their property, and now they want to put a stop to it. And there's a few things that I would suggest from a prophylactic point of view beforehand, and then some things after the fact that you can do. If you represent a client that has this issue, whether you're driving over somebody else's property or they're driving over yours, putting together an actual easement, a recorded easement, is a great idea. You never have to worry about the issue ever again. What's interesting is one of my cases, there is such an easement, but it's been so long and things have been built up so much that the place where they created the easement, which is literally straddling the boundary line, is no longer practical. There have been telephone poles put up in the area, power lines in the area, and what have you. But the intent was there. And so that's one thing I would recommend. With regard to, people's homes. So in Queens County, for example, it's a great place to look at this example. Generally speaking, you can't build closer than 3 feet to the boundary line. So builders in Queens County many times would buy a lot of land, and instead of giving the 10 houses their own driveway, they would put maybe 13 or 14 houses on that plot. And the way it would work is they would build up to 3 feet on one side, and the other side would have maybe 5-6 feet, and you would use part of their 3 feet and part of your 5 or 6 feet, and that's how you would have a driveway. So you would always be driving across your neighbor's property. So technically, and I don't recommend going this way because it's much harder to prove, you might have what they call an easement by necessity, where there was one common owner initially, and the way they subdivided the land, the intent was clear that people were going to be driving across each other's property. That one generally doesn't apply to the example I gave because the land is not landlocked. But what we do have is a prescriptive easement. So time goes by and people are driving across each other's property. So house A is driving over a little bit of B's property. House B is driving over a little bit of C's property, and D is a little bit over E's, and just down the whole block. And oftentimes these problems originate with the corner property, because the corner property, the way it's constructed, generally doesn't need the neighbor to get in and get out. So I've had many cases in Queens County, a couple right now going, where somebody just decides to put a fence up on the boundary line, and now the person can no longer drive in and drive out. And virtually every one of those cases is going to be a prescriptive easement case. Sometimes the surveys will actually show the survey, show an easement right in the survey, but really technically it needs to be in the deed to have real teeth to it. So that's one issue. And as a general rule, liability insurance is not going to cover these issues, but can you speak at all, Roger, to the issue of title insurance on this?
Well, exactly right. In a liability contract, they're paying for bodily injury or property damage. When you get into disputes to the nature of that you've just described, then the policy generally that's going to respond is a title insurance policy, which you take out on a one-time basis when you first acquire the property. And sometimes, as you know, closings can get delayed while the title company does their search and looks for permits and other issues that could come back and bite them later on. But easement issues and that kind of thing are exactly the kind of thing that a title policy is going to buy. If you own your house, then you should have a title policy that would have been part of the process in buying. If you're renting, that's not necessarily the case.
Great. And, you know, let me just jump to something that just came to mind. I was on the phone yesterday with a lawyer. So I have a case out in Nassau County, commercial property, pretty substantial size property, where we're dealing with this issue of adverse possession. And we believe that we'll be successful, that the property was clearly being utilized by my client, and the neighbor was completely cut off from this little section of land. So when the property was purchased, what normally happens is the title company will have a surveyor go out and look at the land to make sure that, you know, what their people are buying, they have access to all of it. And when there's ever a fence up on the boundary line, they will generally say, if it's, you know, showing that that fence is somewhat encroaching on the buyer's land, they'll indicate that you're out of possession. They'll usually put some wording in there that says that the fence is at variance with the boundary line at different locations, and they'll say 0.02 east of the boundary line, 0.07 west of the boundary line, whatever it might be. And that becomes an exception on title. But sometimes the surveyor misses it, and or the title company misses it, and there's no exception. And that's what we have in this particular case. So right now I'm litigating with their private counsel, and now their title company is involved because the surveyor never pulled out, you know, I don't know if they didn't walk the land or what they did, but they never picked up on the fact that their purchaser, that they're insuring, is out of possession of a portion of their land. So title companies are the right place to look to whenever you deal with these adverse possession issues in the first instance. That case actually, you know, adverse possession is a part of it, but a much larger part of that case, or maybe I shouldn't say larger, but a significant part of that case is also water runoff. Everybody has cemented over, and there needs to be a lot of accommodation for storm runoff, for surface water from the rain, and what have you. Again, a lot of these, and just a good word to the buyers, I know people will look at a house after it rains to see if there's any water in the basement, or if it's damp or things like that. But it's good to find out, are you the lowest property in the area? The one that I looked at on Monday in Astoria, my client happens to be, they're actually probably the second lowest. The one that's the lowest is the one that's right next to them, where their drain's not operating. So their drain just plugs up, and the water comes into my client's property. Let me tell you about another case that I handled also in Queens County. There are parts of Queens County that have a very, I guess you would call it a high water table. So you can't go down very deep. And if you do, you're going to be into the water table. And person built a brand new house. It was actually 3 stories. There were some rentals in there, beautiful. Did everything right, except they wanted to not have something called a hanging drain. They wanted to put the drain at the bottom of the foundation. The problem with that was there wasn't a proper angle going out to the storm drains, sanitary drains, and water. And so what would happen is when it rains, instead of the water draining out to the street, my client became the drain for the block. And we were in litigation for that for a while. Now, thankfully, you know, there are lots of insurance companies involved. We had the contractor involved. We had subcontractors involved. And we figured it all out. But very expensive to repair that, because once everything was laid in, to pull it up and redo it was quite a project. So, you know, this is where you're relying upon your architects and your engineers whenever you're doing that kind of work. But anyway, let me move on. Actually, while I'm looking at my notes, Roger, why don't you talk to us a little bit about, you know, whether it would be the tree situation or water damage or whatever else you think might be helpful, and what common mistakes do people make, and what can they avoid when it comes to presenting claims?
Well, we're now coming into hurricane season, and Tropical Storm Isaias obviously was a wake-up call to everybody. But I think what happens there is you have to kind of be prepared to understand what happens. In this situation, there were a zillion trees that got knocked down, power was out, damage all over the place. One of my insurance companies, I can't believe it, but they said they had 400,000 claims. It's a huge number of claims. So they're overwhelmed with claims, and everybody wants the adjuster. It's similar to the way they want PSEG to come out and, you know, immediately get their lines up. That's just not going to happen. from a person power standpoint. So the idea is when you have these claims, typically if your house has incurred some damage, the insurance company will have no problem with you taking steps to reduce further loss. They want you to do that. And they want you to make common sense repairs to preserve the integrity of your house and also reduce any further loss that they might then have to pay. So as long as you undertake prudent and common sense steps to clean up, get the tree, get it off your house, all those things, because you may not get the company there right away, they will usually pay for that type of activity. If it falls on your roof, a portion of your roof, and you decide you want to get a new roof, there you're going to have a problem. So at that point, you would need the adjuster out there so you can mutually agree on how much of the roof is going to be repaired or whether you have to do that. But in most cases, you know, the things that are damaged, you know, you clean it up or you bring somebody in to clean it up, the insurance companies are just not going to give you a hard time. And they're pretty much happy to see that you've taken those kinds of steps. Typically, take your pictures of the whole site, especially if a tree or something fell in your house, then take that picture, take a picture of where all the damage is. In my particular case, I had an outdoor patio table with glass that was shattered by a tree branch. So took a picture, cleaned up the glass, and my adjuster actually just came in this week and had no problem paying for what it's going to cost to replace that. So as long as you show them an orderly sequence of steps taken to you know, fix your place, they're generally not going to give you a hard time. Another thing that is there are some issues sometimes with food spoilage. Your power is out for more than a day or two. We're all at risk of losing, you know, losing the freezer contents. The company will pay for that usually up to $250 or maybe $500, unless again you have a higher end homeowner policy on a big house. Sometimes they have higher limits, but simply itemize, make your list, itemize, and they will pay for that. In my particular case, we had, I think, $213 of food spoilage. No problem. They allowed the claim. So I think by doing it that way, then you'll get things done. You know, you'll get your check, probably not immediately, but you'll get your check usually within a couple of weeks from the carrier, assuming they can get somebody out to survey the damage. The more complete your submission is on the claim, the easier you're going to have it as far as getting that claim paid. So,
thank you, Roger. Couple of miscellaneous items. So I work with some surveyors, and many times surveys are done for the purposes of title insurance. Many times it's done just to convey title. Many times it's for financing. But when you need to really know where exactly that 40 by 80 lot begins and ends, which I oftentimes need to do if I'm going to litigate, we need the meets and bounds type survey. And surveyors will tell you that there are historical maps. Not everybody has access to all the same maps, but that's the way you need to go. So if it's a survey done for $500, I can assure you that that's not one where they're comfortable doing an affidavit. They want to go back out there and look at some things with the laser and take some, what do they call it, some fixed objects, fixed points that have been used before and locate the exact place. Another question that comes up sometimes in these closings, you're about to buy a property and the fence is in the wrong place. And I get this question sometimes from transactional lawyers. How do you address that? Hopefully you'll have a neighbor that will sign one of these boundary agreements. I've done a couple myself, and people always tell me the title company will only use theirs. I've been successful in having mine used a couple of times because I understand what the issue is and I understand what you're trying to avoid. The The thing that you don't want to do is to saddle somebody with a lawsuit as soon as they sell the property. People have lived with the boundaries where they are. They've lived with the fence. If they're willing to sign something that simply says there's nothing as a result of the fence or anything else about the topography that allows one person to have claim or right over another person, that'll usually do it. I know I bought a house once and my neighbor was the nicest guy. He said, Rich, the fence is on your property, it's your fence, even though he put it up. He didn't care. I wasn't about to start moving the fence and he wasn't going to. And I said, that's fine. I had the agreement and that's what you want. So when the title report comes back and it says you are, missing the you're out of possession of some portion of the land, you want to address that. Otherwise, it just becomes a headache down the road. The title company obviously is going to accept that from title. Should you record a boundary line agreement? There are some exceptions to the rule, but I would say, generally speaking, no. All you're doing is, putting something out there that the next time you go to sell the property, it's going to come up to show, hey, there's an issue with this property. The fence is in the wrong spot and everybody knows about it. At the end of the day, as long as you have that agreement, you don't have to worry about it. When you go to sell, you want to give that agreement to the next person to say, listen, that fence that's on your property, they've already confirmed that it's in the wrong spot. Does it make sense eventually to, address the issue? Something that's under the RPAPL, which deals with when people have a de minimis encroachment, less than 6 inches or 6 inches or less, and you don't address it within a year, even though you can bring you can bring a removal of the encroachment action. The courts generally, if that is a structural wall, they're not going to make the people relocate the wall. What they will do is you'll get some damages. It's usually fairly nominal. And you'll also get a court order that says when and if that wall comes down, they have to reinstall it and recognize the boundary line. And so that's what I would put into my boundary line agreements. If they ever take down that fence or it ever comes down, it has to be reinstalled in the proper area. You also get light and air and those types of easements. Those things get a little bit more complex. The issue becomes oftentimes if somebody's built right up to the boundary line and there's a window there and now you have perhaps an illegal lot line window or someone's blocking your air, blocking your light, all issues that should be addressed, when people are filing plans with the building department and many times they need a variance and they'll, have a hearing and that's your time to speak up on those issues. What else? Roy, are you still there? Are there any questions or is that pretty much it?
I am here. We got a few questions by email, but between the two of you, you've pretty much answered all of them thoroughly. Roger, I don't know if you have any kind of things you want to add, maybe light fixtures that get damaged, any kind of thing like that. Depending on what you see clients asking about and wondering about.
I think, thank you, Roy. I think a lot of problems when people have problems with their insurance company, it has to do with expectation. And people think their homeowner policy is going to cover them for everything. I would suggest that you sit down with your agent or company and just do a quick run through on what your policy does and does not do. And with that, I think when you do have the claim, you'll be prepared. I think preparation here is of course the best solution, and it helps you minimize the claims. For example, some people, when we went back to Hurricane Sandy, there was a big run on generators. So you might want to consider buying yourself a generator so you can at least maintain your food and sometimes even your air conditioning. But it just seems to me to make sense to do that, just educate yourself as to what your coverage has. Also know that many of these insurance companies have bundled endorsements that give you extra coverage. And that's sometimes where you'll find spoilage coverage and that kind of thing. So to give you extra money on, you know, cash and jewelry and so forth. So just in general, I mean, you're in danger of having me now talk about lots of aspects of a homeowner policy. Again, if you have a sleeping problem, just continue to listen. But the point is, you have to understand what your policy does and does not cover. And, you know, a frank conversation with your agent or broker, I think, will go a long way to alleviating misunderstandings when you do have a claim. So,
Roy, anything else?
No, that was comprehensive. So thank you, gentlemen. For those of you listening, if you have any questions, legal or insurance, whether they're related to this issue or any other issue you have, feel free to contact us at vmmlegal.com or email us at info@vmmlegal.com. That pretty much covers everything. You're also welcome to visit our website, again, vmmlegal.com, to sign up for future webinars. I hope many will feature Roger in different capacities. We always are putting up new ones about a variety of issues. We have 20 practices, so it can range. We welcome you to sign up and be notified about future events, webinars, etc., etc. Gentlemen, thank you.
thank you. Appreciate being asked to participate.
Have a good weekend, everybody. Stay safe.
Take care. Bye.